Hello, everyone. My name is Joshua Gilliland, attorney blogger on Bowtie Law. With me today for a special sponsored video and audio podcast is Howard Reissner from Planet Data. Howard, how are you?
I'm fine. Good afternoon, Josh.
Let's talk about mobile discovery and cloud discovery. I know you guys have recently done some roundtables and events on mobile discovery, and could you share with our listeners what events you've recently participated in?
We've had a number of roundtable discussions and conferences on mobile devices. We have presented, I think, at least 6 to 8 mobile device CLEs to law firms and corporations over the past 6 months.
I know this is an issue near and dear to your heart, and you guys have really been on the vanguard about this. So let's jump in and talk about some of these issues. How are courts becoming more insistent on mobile data that you've seen in litigation?
Well, I mean, it's not so much insistent on mobile data. The courts are insistent that wherever there's potentially responsive information, that data be addressed in the discovery process. So whether or not it comes off of a laptop or a desktop or a phone or an iPad or a social media site, the issue is that if the data is potentially responsive, then the requested party needs to address the protocols for gathering and addressing the information and potentially disclosing it if it's relevant.
How are you seeing parties comply with those requirements?
Well, I think it's an effort and cost issue. So today the data that is most readily accessible is going to be data that sits on a network somewhere or in a corporation on their servers, or in fact, if they have data in the cloud and they have readily accessibility to that information. I mean, that's always going to be the easiest and most readily available, responsive information. So from that standpoint, we see counsel going back to those areas and trying to comply with the discovery request by going to where the information is most accessible.
Yeah. You brought up cloud data because there are different types of clouds, as any weatherman knows. So you have the file sharing type clouds, you have the social media type clouds, you have something like Google Drive, which can come in different shapes and forms with either forms there, documents that are shared, and other stored data. How are you seeing cloud data come into discovery?
Well, as I said, again, where I think the respondent is looking to access the data that's the easiest to get to. As we move it into things where basically it might be cloud-based, where they have to go now either search for it or go back, and it's not in a file that they can readily gain access to. There seems to be still some recalcitrance in going back and saying, gee, it's more difficult to get at, and they'll go back and say that this may be based upon the proportionality and costs and what's at stake in the case, that this is more inaccessible at this point.
There are a lot of attorneys out there who are highly resistant to change. Some would proudly be the final dinosaur than the first mammal. So taking that into account, that you have, just in our traditions of, say, law school, that there was a decades-long fight for Llewellyn's Socratic method to be introduced into law schools, and we're really resistant to change. How are you seeing lawyers be resistant to mobile data today in litigation?
Well, that's a great question, because as we know now, more and more we're seeing an overlap between the personal data creation and company or corporate-wide data, as we're seeing with so many phones in particular being used in a BYOD kind of scenario, or tablets, iPads, things like that. So the resistance is basically that attorneys, again, would rather go where the data is more accessible. It is generally more difficult to get data off of a phone, more difficult to get forensics copies of that data. You have certain iPhones now where Apple's putting a lock and encryption lock on the newer model so that even they cannot get to it. And lastly, attorneys have to deal with their clients, and their clients are just normal people who have their personal data mixed up with their work data. And I haven't met anybody yet that is just delighted to turn their phone over for a third-party inspection. I misspoke and said it's inspection versus infection. But nobody really wants to have that done, despite the assurances that only the information that is potentially relevant and responsive to the lawsuit is going to be addressed. It's just to tell a client that they have to hand their phone over for an hour or two and have it imaged is not something that attorneys like to address.
No, that's right up there with asking someone to have a root canal in public. It's just not a good plan, and yeah, it's not a good place to be. So let's take a look at law firms, and they have to answer to the court. They have to take care of the clients. They have to meet their ethical duty of competency. What demands are you seeing judges place on law firms as they deal with mobile data?
Well, I think we're still quite early on in that area. Every time I give one of these CLEs, and I've done 3 of them in the last month, and they were with fairly substantial law firms in terms of size, I always ask and these are all litigators, I always ask them, how many of you have addressed mobile data in your litigation? It's interesting, when I gave one to an IP firm recently, intellectual property firm, there's very, very little mobile data addressed in intellectual property cases, absent the small area of trade secret, potential alleged trade secret or licensing information theft. There's been really very little in terms of just pure patent litigation. When you get into more of the other types of commercial litigation or employment litigation in particular, you see more indicia of that, because often some of the information that would be relevant resides on a phone. Nonetheless, back to the first point of the question, well, judges are certainly demanding that the information be responded to regardless of where it may reside. Again, the attorneys will go for what is the most efficient and cost-effective manner of getting it. And so I said we're still early on, because it's still the exception rather than the rule that data that would be highly responsive to a request only resides on a mobile device and cannot be obtained somewhere else where it's more readily accessible. But I think that tide is turning, and as time goes on, we're going to see more and more attention focused that the mobile device data is where the data resides and it needs to be addressed and produced.
So how does reasonableness factor into that analysis and finding out where the data resides?
Well, again, if you're requesting it, you're going to say, listen, it doesn't really matter to me whether it resides on a phone or resides on a server somewhere. Again, from the responsive side, you're going to have to, for example, you might have cases where the person's location is relevant to the claims and defenses. Okay, and that is only going to be found on the device itself, because when we give these CLEs, people are always shocked to realize that when you turn your phone on, it's a tracking device, and it's a GPS. And so when somebody sends out a litany of texts, for example, not only do we know what they sent in the text and the time they sent the text, but we know where they were when they sent the text. And so when those kind of issues become germane to the claim or defense, that's going to be the only place where the data is going to reside, and it's going to have to be addressed.
Howard, it's always educational and interesting to talk to you on these issues. If somebody wanted to have you come in and do the CLE that you guys put together, how can they contact you?
Oh, they can reach us at www.planetdata.com, and we'd be delighted to do that. We'll do it anywhere where there's a responsive audience.
Fantastic. Well, Howard, I appreciate your time and insight into these matters, and I look forward to speaking with you again in the very near future.
All right, thanks. Thanks a lot, Josh.
Thank you, everyone, for tuning in. Have a fantastic day.